So I think it's 1,378 days into the COVID-19 pandemic, right? That's what it feels like. If you guys haven't watched Groundhog Day, Bill Murray, check it out this weekend. You know, we're living it, except this isn't a comedy. Listen, my name is Mitch Jackson, and what I'm trying to do, you guys, is share a business trial lawyer success tip with you guys. Something different, something I've picked up over the last 30, 40 years of practicing law and doing business here on this channel. So today is my favorite negotiation tip. It's a tip that I've used to negotiate multi-million-dollar cases in court. You can use it to buy and sell your house. You can use it to close your next deal. In fact, I think you should. But before we dive in, do me a favor. If you're not already subscribed to my channel, hit the subscribe button, ring the bell, and let's do this. This negotiation tip is something that, assuming you've got a good grasp on everything else, the facts, your lawyer, the evidence, procedure, knowing what your desired outcome is, knowing what your outcome may very well be, knowing what the other side wants and what the other side will settle for. It's always two different things. No matter how much you or your client wants to close the deal, the secret is to give the impression to the other side that you care about negotiating a deal, but not that much. That's the secret. The deal that you're trying to negotiate might be one of the most important deals in your life. It might be one of the biggest deals your client has ever had the chance to close, or maybe something that you or client have been working on for years. It might be the most important thing in your career, and that's great. You're going to dig down, you're going to get ready, you're going to know the facts, you're going to appreciate all the arguments, you're going to know what your desired outcome is, what you can live with, what the other side's desired outcome is, what they can live with. And you're going to prepare internally, inside, outside the presence of the other person or people you're negotiating with, like you never have before. But when you're talking and communicating with that other person, when you're in the same room, when you're in with the mediator trying to get the case done, if you're in with the judge trying to get the case done, you're going to let them know that you care about the outcome, but you're going to give them the impression by what you say and how you say it and the options you present and your body language, that while you do care about getting the negotiation done, the case settled, the deal closed, the sale completed, frankly, you have options. You don't care that much. You set that tone, you do it the right way, and everything else will fall into place. Let me tell you about a little case we had where that's exactly what we did, and it resulted in both my client and my co-counsel, his client, ending up with an additional $400,000 above and beyond the point of the negotiations where everybody was just going to walk away. Now, before I do that, let me negotiate this hill, and I'll pick up at the bottom. So, a case that comes to mind where we did this. A friend and I were co-counsel on the case. We were representing two families whose two sons were tragically killed in a head-on automobile accident out on Santiago Canyon Road, which is a very dangerous road in Orange County, California. And the cause of the collision was the other driver. He had come across the center line late at night unexpectedly and collided with our clients, killing them instantly. After about a year of litigation, back and forth to the courthouse, we finally had our trial date and we're ready to try the case. We had our witnesses lined up. our evidence, our accident reconstructionist. And what happens in Orange County is before you try a case, they have what are called settlement conferences, whether they're formal settlement conferences that you schedule with the other side, or it's an informal in chambers pre-trial settlement conference where the judge gets you in there and does all he or she can to try to get the case settled. I think it's a good thing. So, long story short, we go into the settlement conference knowing the facts of our case, the liability, the strong points of our case, the weak points of our case. Every case has a weak point. And we also realize that the court system back then was backed up. Too many cases, too few courtrooms. The judges were having a really hard time getting cases out for trial. And check this out. Lots of good memories. Lots of good memories at this ballpark. Seen a few kids hit the ball over this fence, I'll tell you. You do not want to park here. Not a good idea. Anyway, we realized that the courts were having issues with getting cases to trial. We also, speaking with opposing counsel, knew that he was overworked. He had way too many files to handle effectively. A lot of cases on trial. Was underappreciated at the law firm. Was basically, I don't think, a happy camper at the time. So when the court asked us to step back into chambers and participate in this first informal settlement conference, we insisted, even though we did want to settle the case, because any trial lawyer will tell you a good settlement's better than a great trial verdict any day of the week, because you know what you're getting. You know what that outcome's going to be. Trial's always a little bit risky. So we're back in the judge's chambers at the settlement conference, and we let the court know we're ready to proceed with trial. Settlement negotiations have reached an impasse, and we'd like to get a jury panel up so we can start paneling a jury, picking our jury, and start our opening statements, hopefully the next day. And what happened is that we were listening, and the judge was sharing, I'm gonna say his or her concerns. To try to keep it neutral here, just for privacy purposes, although it was a public case. The judge was sharing concerns about, we're never gonna get to trial. Everyone's gonna have to keep waiting and coming back day after day after day. The defense attorney was expressing the same concerns. We said, well, we understand that, but what's being offered isn't going to result in this case being settled. And we'd rather just come back tomorrow morning and try to find a courtroom, and we'll keep doing so until we're able to pick a jury, whether it takes 3 days or 3 weeks. Well, we left that day with the new additional $100,000 extra being offered onto what was being offered already to settle the cases. And our client said, whatever you want to do. If you want to settle the case, that's great. If you think we can take a little bit more time and you can obtain even a higher settlement for us, you got the green light to do that. We usually have this kind of client before. It makes our job a lot easier when they trust us. So what we did is we came in the next week. Judge calls us back to his chambers, and we go through the same process. Our position doesn't change. We'd love to settle the case, you guys. The numbers we're hearing just don't work for our client, and we've been given authority to recheck those numbers, which we were. And the judge expressed concerns with the overbooking of the court system. The defense attorney talked about his court calendar and how if we weren't able to get out for trial, he had 3 other trials set over the next 3 weeks, and it was a huge inconvenience to him, wasn't sure how to handle that. And this was just music to our ears, because we knew that there was a lot more going on than just the value of this case. We left that settlement conference with another $100,000 being added to each of our clients' respective original settlement offers. And this went on for 2 more weeks. So over the course of 4 weeks, participating in these settlement conferences, caring, but not letting the other side know that how much we cared about getting our cases settled. My buddy and I, driving back to the office, we actually kind of laughed together on the 3rd Friday. We're thinking to ourselves, every Friday we drive up here and the other side puts another 100,000 on the table. I'm gonna keep coming up here every Friday. This is my new Friday happy hour, right? And the clients were on board with this. They kind of understood the game. And so by the 4th Friday, we go up, same thing happens again. They offer another 100 on top of the original settlement offers, plus the 300,000 that they had offered over the last 3 weeks, 100,000 each week, which put us at the policy we were looking for, which means that's the only insurance that was available. We tapped it out and we got the cases done. The client was happy. We were glad to be able to get this case done. And the judge was glad we weren't taking up the judge's courtroom. Opposing counsel, defense attorney was happy that this was a file that frankly should have been settled a month earlier, the policy. But I should add, this was early in my career and I didn't have the reputation that I've got now, which helps a lot. So they're gonna make us try the case, or at least make sure we pushed every single button and pulled every single lever that we had to before they were going to make their maximum settlement offer. So, couple of takeaways. For the consumer out there, the business owner out there, anyone out there that's negotiating, understand the facts, understand the arguments, understand what's your goal as opposed to what you actually need. What's the other side's goal versus what do they actually need to happen? Ask the right open-ended questions to find the answers to those questions. It may not be what you think. You may think a seller wants to sell his or her house, when in fact what's even more important to them is being able to move from the West Coast to the East Coast to be by their new grandbaby. There are all types of factors that go into why people think they need to get something done. So by combining information and knowledge with your negotiation approaches, with your people skills, if you're a lawyer, with your legal skills, and participating at all times, no matter how much you want to close that darn deal, by having the perception that you do care, as you do about all your cases. But as far as selling this case, look, I'd like to get it settled. But, you know, you can go either way on it. If you want the other side to understand you care, but you don't care that much about getting the case done. So, listen, if you guys want some inside tips on trial advocacy, negotiation, communication, business, little things like this, and you don't mind me breathing heavily while I'm running with my GoPro and sharing these things with you, like I said, subscribe to the channel. Check out the other content that I've got here. Jump over to streaming.lawyer, which is my lawyer social media live video blog. And let's start the dance together. All right, I'm gonna pick up the pace, get back to my office, right? Please, you guys take care, stay safe, bye-bye. So after I got done shooting, I realized I need to add this into the video. A little different scenery, but we're coming up to a really cool tunnel, so I'll share that with you. And that is, every time we went back to the courthouse and participated in settlement negotiations, what my buddy and I, my co-counsel and I did was we directed these conversations to the judge's concerns with the overcrowding of courtrooms, the unavailability of courtrooms, okay? We directed the conversation about understanding and appreciating and empathizing with opposing counsel's schedule. But the fact of the matter is, this is the case that was set for trial. So this particular trial had priority. Over all the other trials that he had on his calendar. Didn't matter what experts he had scheduled to fly in from out of state. Didn't matter what witnesses and conflicts he had with his other cases. This is the case that was set for trial. This is the case that was active. And so we really focused on pushing those buttons. So between letting the judge know that we weren't going to give the judge an out, in other words, absent the judge issuing an order, which the judge has the power to do to continue the trial date, we wanted the judge to know we were ready to go. You guys are gonna get me on this uphill. All right, bear with me. So the point is while we were emphasizing about, the concept of caring, but not that much, we were also pushing the right buttons, with the court, with opposing counsel, to try to position the case so that each and every Friday, more money, a better offer was put on the table. I felt like I needed to add that to give context to the rest of the video. Okay, thanks guys, make it a masterpiece.